Good evening, Mr. Chair, members of the committee. Thank you so much for allowing me to testify this evening in support of legislation that would create an extreme risk protection order for Rhode Island. My name is Telus, and I'm a counsel with Everytown for gun safety. Everytown is the largest gun violence prevention organization in the country, representing 4.5 million supporters, more than 250,000 donors, including moms, mayors, survivors of gun violence, and everyday Americans who are fighting for public safety measures that respect the Second Amendment while helping to save lives. Obviously, the purpose of the legislation that we're hearing about is to create a new type of civil restraining order so that when a person is in crisis and poses a danger to self or others with guns, law enforcement and family members are empowered to seek a court order temporarily blocking that person from having guns. As we've heard, when those who recognize red flags are empowered to act, they can prevent warning signs from turning into tragedy. We know that in many cases, people who go on to commit gun violence display warning signs first, and I won't rehash the testimony that we've heard, though I do agree with it, in particular the effect that this policy can have on people who are inclined to commit suicide. The study that was cited just now, that's 72 lives, that's people's family members. And I guess I just want to reiterate that portion of it especially. These bills would create a process to empower those families and law enforcement to temporarily block gun possession by the people who do pose that threat, while at the same time providing robust due process protections to people experiencing crisis. And I want to talk about that specifically. The bill would create a new chapter within Title 8 of the Code, establishing and defining red flag orders, how they can be sought, and by whom. The chapter would establish the factors that the district courts must consider and specifically set out the standards of proof required for a court to issue an order. They will also set the duration of the orders and the processes for renewal and termination. The bills will also establish the process by which guns are to be turned in when an order issues and how those guns are returned when an order expires. Now, obviously, as with any court order that can impact personal liberties, the process created in these bills was designed to ensure both public safety and the due process rights of all the parties involved. The bills establish clear and appropriately high standards for the showings that must be made before a court issues an extreme risk protection order. The bills make clear the factors that the court must consider and the burden that the petitioner must meet before an order can be issued. And just because some of the testimony that we've heard tonight, I think played a little fast and loose with just how difficult it would be to obtain one of these orders, I just want to read you the standards that are actually in the bill because I think it would probably help just to have it spelled out. For an emergency order, the standard would be probable cause to believe that the respondent poses an imminent danger of causing personal injury to self or others by having in their custody or control, purchasing, possessing, or receiving a firearm. The full standard for a full one-year order is clear and convincing evidence that the respondent poses a significant danger of causing personal injury to self or others by having in their possession, custody, or control, purchasing, possessing, or receiving a firearm. Courts make these types of determinations all the time. This is not at all someone, this would not allow someone to have a dispute with a significant other, write a letter, call someone, and have someone's guns taken away the very next day. There is a rigorous process to obtain one of these orders. The petitions for the orders must be sworn under oath and contain specific factual allegations in support of the claim that the respondent poses that significant danger. And right now, I can just read from the bill. That's state-specific statements, actions, or facts that give rise to that reasonable fear of future dangerous acts by the respondent. So it's not speculation. These are specific actions, specific evidence that has to be brought to the judge to get the order to issue. And there are safeguards in the bill already to protect against some of the potentials for abuse that I think we're all that we've heard about and that are legitimate concerns, and that's why these provisions in the bill exist. Any petitioner, whether it's a family member, a law enforcement officer, who knowingly files a false petition or who files a petition with the intent to harass or annoy the subject, is subject to criminal liability. So that's in the bill, just so we're all on board. The bills also ensure that all parties have an opportunity to be heard on the merits of a petition. Only in the most serious cases where an emergency order is necessary to prevent imminent harm, and that word is in the standard, can an order be issued before a full hearing. These emergency orders can only last up to 7 days, at which point a final hearing must be held. No final order could be issued before the respondent has an opportunity to be heard and to present evidence of why the order is not necessary. And the bill gives a person subject to an order an opportunity to petition the court to terminate it. And I just wanted to, again, clear up a little bit of the confusion from earlier regarding burden shifting. There is no provision in the bill that I'm aware of that shifts a burden to a petitioner to a respondent to get guns back. Under this bill, once the order expires, the subject merely has to go to law enforcement, show proof that the order has expired, and they get the guns back. Now, if the order has not expired, let's say it's a few months into the order, and the subject would like to have the order terminated, that is when the burden is on the subject to show why the order should be terminated early. But I think what we've heard a little bit of is confusing the standard for termination with the standard for what happens upon the expiration of an order. And I'd be happy to answer any questions about that. So with that, I strongly urge you to pass this important legislation, and I would be happy to answer any questions.
May I briefly? Three people ago, there was testimony about the clear and convincing standard and the shifting of the burden, and I believe the witness testified that orders can only be issued up to 1 year. I just want to point the committee to page 6, line 19, which says, orders shall be for a period of up to 1 year unless the court determines that the order should be issued for a longer duration. So I think the point is the court has a discretion to issue a longer order, and if within that period of the order you want it rescinded, it could be 3 years later, the burden on the citizen is clear and convincing evidence. Thank you.